Welcome back to the Trial Bible, the show where we take you inside the courtroom and break down the anatomy of real trials, strategy, psychology, persuasion, and the human beings at the center of the fight. This is a trial that asked the jury one of the most terrifying questions any of us may ever face. What is the value of a young man's life destroyed for no reason at all? Joining me today is attorney Brian Ward, who recently secured a staggering $110.8 million verdict in San Bernardino County, one of the most emotionally brutal civil cases I've ever heard. Brian is our first West Coast guest on the show. Brian, welcome to Trial Bible. Let's jump right into it. I want to start by grounding the listeners right into the story. And it's not the legal story, but the human one. Take us to the beginning. Tell us about who is Gennady Voldz, Glen Bolden, and tell us a little bit about these young men.
So Gennady Voldz and Glen Bolden were two young black men in their early 20s when this incident occurred several years ago. On paper, they didn't have a lot going on because COVID had interrupted so many people's educations. I mean, people in my family, people all across the country, kids that were in high school and college, getting ripped out of the school kind of just changed the trajectory of a lot of their lives. And the night that starts our story here, our two guys are like that. They're good kids. They came from good families. They were expected to have degrees and careers. And because COVID interruption, they just weren't there. They were spinning a little bit. They didn't get into trouble. They weren't looking for trouble. They were quiet kids and they had each other and they didn't have much else going on. They were both really kind kids as well, which is important. And so they're out on a Friday night and they're just having a good time. They hit some bars, they're cruising around, they're going to go to Denny's, at 3 a.m. And they stop at an AM/PM, which in California, that's a gas station. And Gennady hops out to grab a pack of smokes. And when he does, he comes into the AM/PM and, they're about to end their evening. But somebody else is beginning their day, and that's Officer Michael Becker.
Before you go into Officer Becker, how old are these two guys?
21 and 23.
Okay, young couple of kids just hanging out, having a good time, and the incident starts at about 3 a.m. Okay, so we're at a gas station. These two kids are ending their night, and in comes a correction officer named Michael Becker.
There's a lot of interesting things about what's happening with Officer Becker at this moment that are going to come into the liability later. But basically, he's on his way to work. He works at the prison. He stops at the AM/PM to get his morning coffee. It's kind of his ritual. He's got on cop pants. He's got on a cop shirt, but then he's got a windbreaker over it. We're going to come back to that fact later. It's going to be really important. And as he's, making his coffee, he's a old, fat, white guy. He clocks a young black kid that he doesn't like the looks of at the counter buying smokes. And he eyeballs him, man. You can see from the surveillance video, he's eyeballing this kid. And they end up leaving the store at about the same time. What's interesting about this case is how much we know about what transpired that night, but also what we don't know. So I could show you 13 minutes of footage inside the AM/PM, and you can see that Gennady looks like he's just buying smokes. There's nothing going on. And Becker looks like he's just eyeballing this kid. They leave at around the same time, and they hit a dead spot in the cameras. So we don't know what happens between the door of the gas station and the vehicle. What we do know is something was exchanged. A word, a glance, because our guys get in their car, and they're pulling past Becker to leave the parking lot. And Gennady's driving, and he says something to Becker. We don't know what he said. Becker says he cussed at me or something. I didn't care. What do I care? But what we see immediately after that is Becker hauls it. He hightails it into his car and he peels out of that parking lot. And that begins something that we do know and something we don't know. What we do know is that he chased them onto the freeway and started hitting speeds in excess of 120, 130 miles per hour, trying to chase these kids down. In the process, he activates his dome light. He pulls out his gun. He brandishes his gun at these kids, and they are running for their lives. We're never going to hear Gennady's story. Glen's story is, we were scared for our lives, and we were going to hop off at this particular exit where we knew there was a police station. We were going to the cops to try to be safe and end this. Before any of that can happen, though, Becker hits him with a pit maneuver at 90 miles an hour, sends the car spinning and then tumbling down an embankment, and it lands upside down and it's engulfed in flames. Glen Bolden comes to outside of the car, sitting outside of the car, watching the car burning, and he sees Deason hanging halfway out of the sunroof, burning alive. He doesn't know how he got out. Emergency responders are on the scene pretty quick, and in this moment, Becker activates himself because he realizes something real terrible has gone here. So that windbreaker that was covering up his cop shirt, it's gone. Badge, full display. Gun, full display. Walking around the scene like he's a first responder. Okay, so he works for Department of Corrections, that's the prisons. California Highway Patrol, they show up to first respond. You know, we've got citizen journalists that run around, you know, on the police scanners and try to catch video. They're out there. So we've got tons of video right after the crash. And we can see what everybody's doing. And Becker's lingering.
Any video from his vehicle, from the police vehicle?
No video from his vehicle. He's in a personal car on his way to work. That's another fact we're going to come back to later when we get to vicarious liability.
And at some point,
but on the video,
he was brandishing his gun at them as well.
Yes. Yes, he was.
Okay.
So you get to the scene. He's holstered. He's got his badge. He's got his hands on the hip. He's mingling around with CHP. At one point, he's literally hanging out over Glen Bolden's shoulder as the CHP is questioning him, listening to Glen's story, acting like he belongs, acting like a cop, acting like he has access. He tells both the CHP responding officers as well as a journalist guy out there trying to get footage and interviews, lies. He starts lying immediately and says, these kids were chasing me. And that's what happened.
Was there footage of the chase?
All you get, once we see that car pull out at AM/PM, the next bit of visual evidence we get is the car is on fire. So okay. We had no evidence of the chase, other than what we can surmise from Becker's lies, what Bolden does remember after, because he's amnestic to a lot of it, and what we were able to put together through our recon. And the recon really nailed home that Becker was in pursuit and hit him, you know, with the front right of his car to the rear left of their car, kind of classic pit maneuver. Looks like a cop move, and that's how he ended it. The journalist asked Becker, do you think this has anything to do with your job, being a prison guard? Becker's all in. 100% this has to do with my job. And it's crazy what happened out here tonight. Becker can't go to work that day, right? Because he just got involved in this. So he calls his supervisor, says, I'm not coming in. His supervisor and everybody at the prison, this stuff is on YouTube within like an hour. They all see it. They see him, you know, with the crash car, with the bloody kids everywhere, and with him in full uniform hanging out saying, this was related to my work. And what's interesting is what happens to him next, which is absolutely nothing. He goes back to work, carrying his gun, back on duty. Nothing happens. Now, their policy manual says you've got to report even an accidental use of force, even off duty. So, okay, he calls the supervisor. Did he do that? Maybe he did that. What did his supervisor do, though? And the answer is nothing. Didn't ask him any questions. He didn't institute any formal review, no disciplinary process, no administrative suspension, just no inquiry as to how he could have ruined two young men's lives out there that night, using his gun, using his car, and walking around with his badge. What's interesting on the video is that although he makes himself try to look useful, he doesn't lift a finger to help anybody. He stands just out of the way as they're trying to save Deason's life. And they get Deason out of the car, they pull him out through the sunroof, and he codes. He ends up basically dead. So he ends up dead for about 9 minutes. Yeah, I've told you this already, Gennady, and it's a hard thing to say, and I had to tell the jury this too. I wish in my heart of hearts that he had died right then and there. That would have been a much better outcome than what ended up happening to Deason, and that'll help you understand why the damages were. We'll
go into damages in a little bit. I want to stick to liability here. Let's talk about the penal code. What is the applicable penal code that applies here when we're talking about a corrections officer who is off duty, has not clocked in, to his job yet. What is the code that you believed was applicable and was going to stand in court?
California Penal Code's a mess because we classify so many different kinds of cops. So if you're campus security, you've got a penal code. If you're Department of Corrections, you've got a penal code. If you're a sheriff, you've got a penal code. If you're probation, you got a penal code. And each of them has some important language about what each of those roles are. But then there's also kind of a catch-all provision that basically says if you're sworn and you've got a badge, you do have peace officer authority 24/7 across the entire state. And you think about it and go, that makes sense, right? If I'm a cop and I see something bad happening, I have to be able to effectuate an arrest, right? If I'm in the airport and I see somebody getting held up in the parking lot, I'm a cop, I'm sworn, I have a badge, I can do something about that. So the department wanted to say, no, you got to read just the department statute for corrections folks. And if you read just that, then, he really doesn't have any authority when he's outside of the prison. And they filed a motion for summary judgment on that. This is years ago, and it's while the case was with another very famous law firm. And the judge granted the MSJ on appeal and held that the penal code was narrow.
So let me just backtrack to the listeners who are attorneys, who aren't attorneys. An action is started on behalf of these two young men against both the driver, the officer individually, and the California Department of Corrections, assuming that vicarious liability was going to hold them in. At a previous firm, the defending California Department of Corrections files a motion for summary judgment. It gets granted. They're out of the case. And then it goes to appeal. And the appellate court says, no, they were wrong. You're back in.
Yeah, and the appellate court expressly says because the statute says that you've got 24/7 peace officer authority across the state, that the jury has to hear that. And they have to consider the facts in light of that law. Okay. And so I want that's great.
I want to still set up, because this trial still is very difficult at this point, despite it may sound very nice right now to most attorneys listening or most people. At the end of the day, you don't have a driver. D-Son unfortunately lost his life. You don't have that story. And my understanding is even Glen Bolden's version, he's forgetful and he doesn't really remember exactly what happened in those moments. And what happens with Corrections Officer Becker?
He defaults. So he does not answer. Once a lawsuit was filed, the department gets their head out of their ass and quietly tells him, without initiating any formal policy, you need to retire. So he's allowed to retire with no discipline, no investigation, and his full pension. And then he skips town. The police do eventually get involved and investigate it as a crime, and they realize he's lied a bunch of times, and he takes a battery charge, and he does a couple months. And all of this, our lawsuit goes on, and the minute he gets out, he's fucking gone. He's off to Arizona, and now he's outside of our subpoena power, so we can't depose him, we can't compel him, we can't bring him in. So I've got neither driver and the passenger also can't testify to what occurred. We have some limited forensic evidence that we were used to reconstruct some of what happened. But in addition to those gaps, we also have some undisputed facts, which is Becker was off duty. He had not clocked in yet. He covered up his uniform. The pistol that he was carrying is his personal pistol. It's not issued by them. So, everybody kind of looked at this and said, Ward, you're kind of crazy for trying this case because it looks like a psycho, not a cop.
And you don't have your villain even to testify, even to mention what his version. You have nobody here. So
yeah,
what is that?
And I've got 4 different versions of Becker because he keeps changing his lies. So you don't even know which story to pick.
And you make a great point. I mean, he might have sounded so crazy that almost villainizing him would do you more harm than good. So tell me what you do as your trial team starts to assemble and this case is about to go forward. What is your collective thought on What do we have to do here to win?
I smelled something here, and the case just it tickled me. It got me going on something. For context, I hadn't tried a case in 2 years, and that's not because I don't try cases, but every case I flagged to try in those 2 years settled, which is great news. So I was number one. I was just ready to get back into the ring. I needed reps. I needed something. I needed that juice flowing again. Another thing that I think is important to talk about is what was hanging over my head. Is my last verdict was a $63 million verdict on a toxic tort case out of Santa Maria in California, where Chevron, poisoned the ground, and my guy got multiple myeloma. And that was a big, important record-setting verdict, and it defines a career, and it was fun, and I was popular, and it was exciting. But you know, the ego gnaws at you a little bit, and the profession gnaws at you a little bit, and you wonder, well, what am I going to do next? And what does my next result say about what my trajectory is? So I just want to be candid. I was in my head, right? And I'm not proud of that, but I just want to say out loud that we do think about that kind of stuff. So I was like, I want a case that I believe in. I want a case that's challenging. I want a case that's fulfilling. Frankly, I wanted a case that was weird and had a real challenge to it. And I saw this one. I said, we can bifurcate this thing. And look, we're going to know in 2 or 3 days whether we've got liability. So let's dig down. Let's figure out the liability case. We had very little time. I stepped in right before trial. So we hit a focus group. And in the first focus group, I said everything. Just like, let's go all the way, man. Like, Becker's a complete psycho. He's unhinged. Introduce everything. And the results were unanimous. You're never going to get vicarious liability when he's that much of a monster. And there was a completely proportional response. The more evil he is, and by the way, he's evil. The more evil he is, the less cop. So that's it. So now I'm like, where's my sweet spot? How do I pull back on just being honest about what a creep this guy was? Meanwhile, the Department of Corrections understood the same issue, so they're throwing him under the bus as hard as they possibly can, making him an unhinged psycho. So we did a focus group the second time and pulled back on it, and we had mixed results in terms of the liability. We started to think we understand if we do a voir dire right, we have a chance of maybe winning this thing. Maybe we can win this thing. I was about as confident as we were going into liability. But I was like, I want a rep, and we'll know fast. So I was like, giddy up, let's get after it.
Give us some more juice on the county itself, San Bernardino. And I think we're missing a key piece of evidence here we haven't spoken about yet, the blood alcohol content of the driver, D's son. So give us all of that into perspective as you're going into jury selection.
San Bernardino County is the largest geographical county in the country. We're huge. But we've only got a couple million people. And in post-World War II America, San Bernardino County was heaven. It was a place where you could come back from the war, you could start a family, you got your GI Bill, and here's what you could get. You'd get a single-family house that you could afford with sidewalks in a neighborhood, people like you, young families. You could get work because we had rail yards, we had aerospace, we had military, we had manufacturing, and you could get great jobs that would give you a pension and a life, and it just seemed like the sunniest place in all of America. And it was, up until we were born. And in the 80s, a bunch of hits came. You lost the rail yard. You lose aerospace. It migrates to other places. They shut down the air base. So all of these good government military jobs are gone. So then your tax base is gone, and then your revenue is gone, and then people are moving away to follow industry, and the city and county end up either in or on the verge of bankruptcy. And then you've got this other thing that's happening in LA, which is LA is gentrifying through the 90s. So, you watch, Boys in the Hood, and Menace, Don't Be a Menace, and you think South Central. What's happening in South Central is all those houses are selling, and all those neighborhoods are turning. And all of those gangs that were rooted in those neighborhoods had to follow their families out to more affordable housing. And since San Bernardino tanked, all of it came out to San Bernardino. So now we've got an import of all of LA's gang culture. moved over to San Bernardino. Everything good left, everything bad came in, and it's hard to describe how desperate a place it was and is and has been for 25 to 30 years. So that's the context. In San Bernardino, it's either poor, young, working class, or older, poor, and conservative. And those aren't usually the ingredients that people are going to tell you mix for really generous juries.
The neighborhood that you're in, that the trial is in, I think sets such a big standard. I spoke to
Hmm.
so many other lawyers where they integrate into that neighborhood, even though they're not from it. They make sure jurors understand, like, look, I'm here representing one of your own. Was there any of that? Do you do any of that in jury selection? Because you're, a white guy
Yeah.
that looks like he
No,
lives
look
a
at me,
pretty
right?
comfortable life.
And those things are true, right? And I'm not going to hide from them, and I'm not going to pretend that they're not. So here's some more context. I live in San Bernardino, and you're going, Brian, what the hell are you doing living in a place like that? Well, San Bernardino, the valley where most people live, there's mountains, right, on the edge of the valley. That's why it's a valley. And I live in those mountains in a tourist community called Lake Arrowhead. So I live in Southern California, but I get four seasons. We have lake, I have, trees and blue skies. And, like I said, it's a vacation spot. And if you're going to call anything in San Bernardino bougie, well, I live in the bougiest spot.
Okay.
It also means that when I go out to the edge of the mountains where I'm prepared to drive down, I look at the courthouse. I look at it for 35 minutes driving downhill all the way. I mean, it's just the biggest building in San Bernardino. So I also get jurors coming from the mountain as well. They got to drive down for jury duty. So luckily, what I had is I have 4 or 5 members from my specific community in the jury pool. And we are a small community. If it's not a holiday weekend, there's like 8,000 of us up here. So I got to do things like, hey, do you recognize me? Do you see me at the post office? Do you see me at the grocery store? If you do see me at the post office and the grocery store, like this weekend, like I'm going to run the other way. So immediately I get to signal that this is also my home.
From here. Yeah.
Yeah, I'm from here. Now, that was easy for me, but a better point is if you're going to go to places where you're not from, boy, you don't lie to them. Don't tell them you're from there, but understand that place and respect it. In that Chevron trial in Santa Maria, none of us were from there, and we were clear about that. But we understood, and we spent time there. You have to understand, what are the neighborhoods? What are their identities? What are their neighborhoods called? Do you know how to pronounce them correctly? Do you have some respect for where you're at? In that case, we had Alston and Bird on the other side, one of the biggest firms in the country. And in the middle of trial, they referred to the city where our courtroom was in, where we were at that moment, as Santa Monica. And for a New Yorker, Santa Maria and Santa Monica might sound like the same thing, but in
Very
California,
different places.
you cannot be more different. And they did it just ignorantly, and the jury hated it. You know what I mean? They're like, you don't even know where you're at. That's so disrespectful. So I had that advantage here built in. So I kind of already knew that stuff. So that made that a little bit easier.
All right. So let's reshift back to voir dire. We have a correction officer defendant who's in default. We have 2 young black kids. We have, events that have happened that no one can really say for certain what happened in those moments in time. And you have the driver who has a pretty high blood alcohol level to him.
Yeah. So we had competing experts on it. Our experts got him, with a rising blood alcohol theory at just over 0.08. Their expert, kind of went the other way and has him at like a 1.2. So that's clearly a bad fact. What are we going to do with it? And, the answer is be honest about it, but don't highlight it. So we offered a stipulation to the state that, look, we'll stip it was over 0.08. That's it. You know what I mean? Nobody has to call any witnesses. You get to save the money. You're the state. You're cheap anyway. The state attorneys had to fly in, and they were staying like at the worst hotels because the state would only give him $120 a night in San Bernardino to find a hotel. So I felt a little bad for him, but they didn't have the money either. So they're like, great, I'm stipping. He was drunk is basically what they think they got out of the stip. Is he's over .08.
What is your advantage to stipulating to that?
We don't have to belabor it. We don't have to do cross exams. We don't have to spend half a day going through toxicology because, one thing I repeat over and over again to myself is the trial is about whatever you talk about. And if we're talking about blood alcohol level through a minimum of 2 witnesses, then all of a sudden the trial's about his blood alcohol level. But if we don't talk about it that much, right? I don't want to lie. I'm not going to hide from it. But if we don't spend a lot of time on it, it's not as important. So we rip the Band-Aid off in mini opening in voir dire. We get a mini opening in California, which is great. I get 3 minutes to tell them everything that's wrong with my case and invite them to tear me apart in voir dire. And in voir dire, we had to deal with the alcohol first and foremost. So, I just said, hey, folks, you've heard what you've heard, and you know that there was 2 young kids out drinking, and they ended up dead or injured on the side of the road at the end of the night. Just knowing that, if that's all you know about this case, who already, I raised my hand to Ma, who already knows how this ends? And people are like, you go out, you get drunk, you get on the road and you die, it's your fault. That's easy, right? And then from there, you can establish the cause challenge is really easy. Those people are going to volunteer themselves right off the jury. But then you're going to have people that want to come and defend it a little bit. So we had people go, no, I need to hear more because they were like, look, I was young once. I went out, I drank, I had a good time, I kept myself safe, and if I ended up dead, I would prefer that people gave me the benefit of the doubt and at least listened to how I got there, right? I just don't think it's that simple. So then you create a really great dialogue around it. The jurors expose themselves and you try to pick them out or get them established for cause accordingly. But the thinking on that is not as uniform or monolithic, I think, as you would assume, because there's a lot of people that go, I don't care, or I need to hear more, or kids will be kids, or I'm downright offended that the defense is just going to say he's drunk and that's why he's dead.
And so do you also touch on the fact that this is a correction officer? How many of you feel that because, police officer is involved here, they are immediately right or wrong or any of that?
Yeah. You have to do all of it. And it was really complicated. In San Bernardino, you're gonna be hard pressed to find a juror who doesn't have a family member involved in law enforcement one way or another. Because we do have prisons, we do have jails, we've got sheriffs, we've got police departments, we've got highway patrol. So it's really common to have jurors with law enforcement backgrounds. It's probably a mistake that we made in the case. There's a big mistake that I think led to one part of the outcome, but I think I look back at jury selection and there was a mistake that I made. And it was, there was a gal who, and we had a couple days of voir dire because it was hard to get a jury with these facts. On the second day of questioning, volunteered. She goes, oh, I just remembered my uncle was a corrections officer. And we thought, she seemed like a good juror overall. Her profile seemed good. Her answers seemed good. But then we were like, how did you forget that for a day? And I don't think she forgot it for a day. And so
You left her on?
We left her on. And I'm going to tell you right now, that's on me. I accept responsibility for that mistake. And she's one of the problems that was caused in deliberations, which we'll talk about in a little bit.
Okay. So let's get to the actual trial itself. What does the liability case look like when you don't have either plaintiff or the villain that caused this whole massacre?
Yeah, it's tough. We had depositions and testimony from some corrections officer folks, like his supervisor and some of the people higher up that do training. We really drilled down on their policy manual and said, well, this is how things are supposed to happen, right? You guys have rules. And in the end, what we really wanted is how do you get the department on the hook, right? Becker's conduct is Becker's conduct. It doesn't matter which version you believe, it's not good. So what are the legal ways that you get him on the hook? So, we pulled up our jury instructions. We looked for all of the exceptions to vicarious liability because he's not on the clock. Remember, can't change that fact. He had not clocked in. So you go looking for other stuff. Like one argument that we thought was really strong was ratification, which is did the department behave in such a way after the fact to have ratified or approved what he did? And what we discovered was, number one, that there was no investigation, no impact on his personnel file. So it's kind of like you kill a kid on the side of the road and there's no investigation.
At a boy, basically. It's a pat on the back.
Well, that's what's really funny, because then Nick Rowley and I were talking about it, and we were talking about what are we going to do, and we came up with, in rebuttal, we're going to tell the jury if he had done the same thing and a box of fentanyl fell out of the back of the trunk, they would have pinned an award on this guy, right? Like that would have been cop stuff, right? If there'd been fentanyl, that would have been cop stuff. So that got me thinking. I was like, I don't want to make that a hypothetical. I want to make that real. So we started digging into the CDCR website and their archives, and it turns out that's exactly what they do. I found at least a dozen examples of off-duty corrections officers in their uniform, in their personal car, on their way to clock in, going Rambo, and literally getting an award from the governor for it. In uniform, on company time, press release, goes in your personal file. That's an attaboy. So I wanted to hammer them on the hypocrisy, because that drove me crazy, that they get to pick and choose after the fact who's being a cop, who's not being a cop, whether it's good or bad press. And so I pulled out all those, press releases and the photos and the awards and just crossed everybody on it. And, got them to admit if this had gone better, it would have been an award.
So what happens with the trial judge and the actual law that comes into the case and the jury hears?
I want to say this. I thought our judge was great. I really do. I really enjoyed trying it in his courtroom. I think he enjoyed watching the advocacy. It was overall a good experience. But even people you like make mistakes. Now, the Court of Appeals, we know, had come back and said, you get 24/7 peace officer authority statewide. And the state kept trying to re-argue their narrow construction to both the judge and wanted to do it to the jury. So we're hammering them on motions, just like, they can't do that, they can't do that. And then we finally, asked for the one thing that the Court of Appeals said we were going to get, which is the jury needs to be instructed that he's got that authority, and then they can apply the facts to that law, and that's why it's a question of fact, and that's why the MSJ was wrong. And the judge did not give us that special instruction. And normally, I would say, I get it. Why would you? I do my best to avoid special instructions because I'm trying to keep my verdicts. And in California, you're going to lose. I mean, if your special instruction is even suspect, you're going to go retry your case. And I'd rather do it clean. But on this one, we had no choice. We thought nobody has a choice. By the way, you don't have to worry about an appeal because the Court of Appeal literally already told us that this is the right answer on this exact question. So, chill out, everybody.
Law of the case?
It's the law of the case, and I repeated it so many times. And in the end, I'm going to speculate wildly here. I think the judge his special instruction alarm went off and said, you're going to go through an appeal like how many more times? If I don't give you this and you win your case, you don't even have to do a perfunctory appeal. You probably just keep your verdict. And I think he thought we were going to win. I think he was looking at the evidence and was like, you got this. I'm not going to risk what I perceive to be an appellate issue when I've been watching the trial and I think you're there. I think you're getting there. So he said no. And what that allowed to happen is it allowed the defense attorney to stand up. The first thing he said in his closing, he goes, members of the jury, Officer Becker absolutely did not have 24/7 peace officer authority across the state, full stop. And I objected. And the judge just, move on. And the judge and I shared a look. And in that moment, again, I'm speculating wildly, I think I saw his eyes apologize because he saw what happened. So now I stand up and I'm like, nuh-uh. And I don't have the credibility of the law behind me. I don't have 4 other corrections officers lying on the stand saying I don't have any authority when I'm not in the prison. So that created a real problem for the jury. And what happened in the jury room is my mistake, the gal that I left on, and a retired firefighter, who maybe I shouldn't have left him on either, they both had some familiarity with the penal code. So they dipped into their own personal knowledge and then started explaining to other jurors how they think the penal code works. So on top of an instructional error, now you've got an instructional error that has invited and led to misconduct.
How did you learn about the conversation in the deliberation room?
You got to talk to the jurors afterwards, and we had a juror that was with us 100% all the way, just really, she was leading the charge for liability, but she doesn't have any cop background in her family, so she didn't have any credibility when it came to that argument. So you've got this old retired firefighter white guy, you got this younger gal who purports to know because of her uncle, you got no instruction from the judge, and you've got conflicting evidence. They started out split. They started out split towards vicarious liability, and these two, by interjecting that improper matter, brought them back to no vicarious liability, which is a shame because we had really great routes to get there, right? We had not only the ratification, which I thought was a slam bang, like you guys literally reward this kind of behavior all the time, but we also had an exception to the going and coming rule. Importantly, the prison does not provide a locker room for its staff, which means they have no choice but to arrive in their uniform. The wearing of the uniform is what confers that 24/7 authority. If I see you're in uniform and I see your badge and I see your patch, I have to stop as a citizen. I don't get to say, are you on or off duty? So it forces them, number one, to be off duty but in the world in uniform, which invites a lot of confusion about what their role is. Also, it means that if they have personal items that need to be kept, they must be kept in their car. There's nowhere for them to keep a personal item inside the prison. So in California, we've got an exception that says, well, if you're coming or going, you're not vicariously responsible, right? Unless the employer derives some benefit about the use of your personal vehicle on the way to and from work, and they've come to rely on that benefit. So I thought that we had a really strong argument that we had an exception to the going and coming rules because they forced these people to use their personal cars as their lockers, and that was part of a benefit. Right. So we thought, well, that's really good too. And these are all really good legal premises that can get us there. What it couldn't overcome was the gap in the law.
So tell us what the verdict ended up being in totality on the liability side of things.
On liability, it was Becker was negligent, obviously. Becker caused injuries, obviously. It was that the CDCR was not vicariously responsible for Becker's conduct. And most importantly, that San Voldz had 0% negligence.
And tell me why that's so, most importantly. Tell me the significance of that.
It's hard to overstate how important that was, because in order to understand, we have to go back to the minute where he does not succumb to his injuries on the side of the road. He is resuscitated. He is saved. He is burned over 3/4 of his body. His rectum has been impaled. He's got broken ribs, broken vertebrae. I mean, he's just an absolute mess. And by the time he gets to the emergency room, the medical personnel don't have nobody really knows what happened. So medical personnel have this sense, or were somehow conveyed by a paramedic, that this was a kid that was running from the cops. And when you come in like a mess like that, and they think that you're a criminal that was running from the cops, a number of things are going to happen. Number one, your dignity is going to be reduced. The level of care that you're going to get is reduced. The level of care that your family members are going to be afforded is going to be reduced. Bias will creep in that maybe this kid had it coming. He deserved it. He did it to himself. I love emergency room people, but they're human too. And Mom, Gwendolyn Adams, San Voldz' mother, at the emergency room was treated terribly. She was treated like her son deserved this or was worthless. And the sad part is that Desan, he lived for 18 more months, if you can call it living, which is, he was intubated. He went through a number of surgeries, including failed surgeries. By the time they evaluated him in the ER, his right leg was basically already gone from the spinal cord compression. So they went in to try to do the spinal cord release, but his vitals crashed and they had to abort it. But then they discovered he had compartment syndrome in his abdomen, and they had to do that or he was going to literally explode. So they sliced his abdomen, and the pressure was so great that it expelled his guts forcefully. And that's just day one. Then you get to amputations, re-amputations, to the debridements. The pain was so bad that they had to start putting him under general anesthesia just to do the burn debridements. So he went under general anesthesia like dozens of times. It's unimaginable. I've never, ever even heard of something so horrific happening to a person. When he was admitted, he weighed over 250 pounds. So, built guy. When he died, he was 120 because he just kept losing parts of himself, parts of his body, parts of his skin, parts of his organs, part of his vital essence until, when I showed the jury the last picture before his death, it's almost impossible to look at. It looks like it came out of a horror movie, but even worse, if you can imagine that. To think that it's hard to even say that that was living. So for 7 years later, for mom to finally have her community say he didn't do anything wrong. He wasn't a criminal. And then it's not his fault. She needed that. She needed that, or her life was never going to continue in a way where she could ever have peace again. So we're going to talk about the numbers in a little bit. Numbers are really exciting. But that, giving Gwendolyn that gift of her community telling her that hers was a good boy, her boy didn't do anything wrong and he didn't deserve it, is something I'm going to carry with me forever.
Those moments are the highlights of our career. Those moments are why we went into this career in the first place. Those moments, I think, are lost on a lot of us through the everyday of handling these cases and settling and getting money. And it's that moment when I read about your story that made me want to share this with our entire community. Let's not forget that that's what this is about. I just recently had a case where a father got rejected by 10 different law firms. His son died on campus, got hit by a bus, and everyone was telling him, you don't want to see the video. Your son was responsible. He skateboarded right into the bus. And he was just looking for a lawyer to can you just get me the video? I don't want to take anyone's word for it. These are humans that we're representing. They have families that give a fuck about what happened and getting to the bottom of the truth. That's what this was about. That's like, I mean, tell me about the feeling of when, I know it sucks that you didn't get that the trial judge didn't get the law right. It sucks that you're going to have to go through an appeal to bring the corrections facility back. But tell me about that feeling of knowing that Gwendolyn, was she sitting in the courtroom when the verdict came in? Yeah.
Yes, she was.
Tell me about that moment right there.
And Deeson's sisters, 2 sisters and mom, were present for the verdict. Look, we already know that we lost on vicarious liability in phase 1. But we kind of expected to. After we got after we were denied the instruction, we kind of knew that was a likely result. So you're looking for whatever win you got, you know what I mean? And the good news is if we got vicarious responsibility, we were going to get a huge verdict and the state can pay it and mom was going to get paid and that was going to be a lovely story. But here's what I knew about Gwendolyn. She didn't need or want the money. And if she had gotten the money, she was going to turn around and give all of it away. So, one thing I think is really important and I do this for a lot of reasons, but in my intake with a client, whether that's a week before trial, because I'm stepping in, or, it's pre-lit, I say, if I could wave a magic wand and it was already over and we accomplished everything that we wanted, what does that look like for you? Because a lot of times they're going to tell you something that you cannot accomplish. And I would rather know and communicate about that up front. So sometimes they say, I want revenge. You're not going to get revenge, right? So I can't help you with that. I want money. I can help you with that. If I know what you want, then I can do my job to make you happy. And what Gwendolyn wanted was her son to be vindicated. She didn't want the money. So in the end, would it have been cooler to come on a podcast and talk about a collectible $110.8 million verdict? Yeah, probably for my ego and my career. But that's not what my client wanted. What my client wanted is for the jury to speak the truth about her son and her son's value. And I accomplished that. So if that was her one goal out of this trial team, we did it. We did it.
I think you said in your closing, and I thought it was just so profoundly strong, you tied the value of these boys' lives to the value of the community itself.
And mom helped because mom's testimony was extraordinary. Here's what mom testified to. Dison's dad wasn't around, and she didn't know how to raise a boy. And it was the people in her community, literally her geographic community, people in her church, people around there, that stepped in and taught her how to be a mother, taught Dison how to be a man. So, it for her, it really took a village. And look, all the bad things we say about San Bernardino, people live here, right? We live here and we have community. There are strong community organizations. We care about each other. And maybe we have to care about each other a little bit more because we don't have things necessarily as easy as Santa Monica or Beverly Hills do. So she kind of really did that work for me by explaining that Dison was a product of the community already. And she testified really powerfully that she had a deal with Dison that he was going to finish his degree and that he was going to marry a good woman and that Gwendolyn was going to be her best friend so that they would know that they have that bud of community so that family would grow and continue to contribute to the community and give back everything that Gwendolyn had received. And I know for a fact that would have been the case, right? That's the trajectory that Dison belonged on. So once she gave to me what the community meant to her, then it was really easy to give the community back to the jury, to give Dison back to the community and have the community speak about what our values are. Because again, it's easy to be like, two drunk black kids that aren't going anywhere die at 3 a.m. on the freeway after getting into a fight with a cop. It's easy to write that off, and everybody did. Right? Almost everybody told me not to try the case, not to take it. They wrote that off. But this jury saw something differently. They saw, and by the way, these people, I reminded them of all of that history of the community that we talked about earlier. We talked about the backstory of San Bernardino and what it means to be in a place like this. And every one of them was nodding.
At what point do you do that in the trial? Are you doing that in opening, in closing? How do you go about doing it?
We get through phase one. We've got the verdict we discussed. We moved to phase two, damages. Initially, the judge said, well, let's just do a default prove-up. Since the state's, out on vicarious responsibility. I said, absolutely not. You told this jury we're doing 2 phases, and they just did their job on phase 1. They got to do their job on phase 2, right? Like you promised them they got to do this job, so you're not cutting them loose. And the judge goes, I totally agree. It's a brilliant idea. Let's let the jury finish their job. And so the damages case was basically a default prove-up, but to a jury. So nobody got crossed. Now,
how many lawyers would not have done that? I just want to emphasize the importance of, no, let's finish this. I don't care if we're going to see $1 from this. Let's finish the fucking job that we started. Yeah. Well done.
And here's the thing.
Keep going.
I knew they cared.
So excited for you, man.
I knew they cared already. How did I know? Because Dison was 0% responsible. So I knew they loved him. Right? And just because they were misled about the law doesn't mean that they didn't care. So I still trust them at this point to do the right thing. So we get into it. We put on witnesses. We did a doctor's summary of Dison's care and his 18 months of torture. We just admitted it, read it into the record instead of calling the doctor. And then we put on a sister, we put on Glen, and we put on mom.
Tell us a little bit about Glen's injuries.
Glen had a head injury, so he wakes up from consciousness, got a brain injury, he's got lacerations on his scalp, and blood at the scene. So a well-documented TBI, but Glen didn't have any resources, and he was a young man, still developing, and if you've ever had young men with TBIs, you know that they get really angry. They get sometimes self-destructive. They isolate themselves either intentionally or accidentally by virtue of their behavior. Glen was pretty wayward. He had he had found himself homeless because he had compromised every relationship with someone that was willing to help him before, and he was really lost. And he's got the brain injury, which he doesn't have any perspective or tools to help him deal with. So it's a pretty sad story for Glenn. But, at some point, kindness will always win. So his grandmother gave him another chance, and took him in and gave him a lot of love and a lot of patience. And he worked really hard to get better and to have some clarity about what was happening with him. Then his grandmother had a stroke, and he cared for her through that. And I think that taught him a lot as well. And he got back up onto his feet. And by the time we were at trial, Glenn had gone from being homeless to working for a nonprofit that places homeless people into housing in San Bernardino, and was really proud of that turnaround. And in fact, kept track. He had a count. He knew exactly how many people he had housed and how he had helped them. And had really had a wonderful kind of redemption arc.
Was he present during the trial?
He was. So I don't really have typically my plaintiffs hanging out in the courtroom. I have them come maybe for opening, obviously when they testify, and then maybe at closing. So Glenn came for opening, he came for his testimony, and he came for closing.
The numbers, let's get into it. What'd you ask for? What did you get?
So in the numbers, what we got was Glen Bolden's past non-economics were $5 million. And we told them, give $5 million. So they did. In terms of Glen's future non-economic losses, we told them $10 million. They gave us $10 million. So Glen's total verdict is 15. Then we had Deson's economic damages from the hospital stay. We told them what the number was, $5.68 million. They rounded that number up to $5.8 million. And then the wrongful death damages for his mother, Gwendolyn Adams, were $90 million. And that is exactly what we told them the damages were worth.
So they were with you. I mean, they really felt the story. They felt these two boys were completely innocent, and it's just a really tragic story that they were a part of.
Yeah. But the good news is we know a little bit of how maybe this will not end, but continue. The judge kind of made a funny comment after the trial, and he was like, well, I'll be retired by the time you retry it. And I was like, I appreciated it, but I didn't appreciate it. I think the acknowledgement was there that is what's going to be inevitable. And in the end, he thanked me for forcing him to keep the jury for damages, because I think he looked at what happened and he was like, I'm an elected official. I can't give you $110.8 million, right? I can't have a reputation of giving out 9 figures on a bench trial. You know what I mean? So I think he was like, thank you for making them do it. And thank you for having the wherewithal to know that that was the way to get to the right number. And by the way, that's the right number. I just don't think he felt that he would have ever gotten there. So now we're in appeal, and we will win our appeal, and we will get a new trial. So, we went, and what do you think the effect of that is going to be when we get our new trial with already 110.8 million on the board?
Yeah, it's extremely powerful. And, you said, I am going to try this case over and over and over as many times as I need to until they get it right. And those words are just, they're so powerful to really stand up for, what it is that we do and the people that we do it for. Like I said, it's the whole reason of this episode. It's to make sure we don't forget. So I'm going to ask you, for the lawyers that are listening who may never see a dollar collected on a verdict like this, they face some uphill battles. What do you want them to understand about why we still take these cases, why we try them anyway?
Well, let's look at all of the benefits that this verdict still has, being unpaid and at the moment uncollectible, because it still has extraordinary value. We've talked about the human value and what it means for Gwendolyn to know that, this community does value her son in the exact same way that she did, which is completely So that's worth something as a human being. It helps me sleep at night knowing my character is sound. But what does it also tell the rest of the industry about San Bernardino? What does it tell the insurance company matrices and the actuarial tables about what the value for these cases is in a place like San Bernardino? So now there's a data point that is irrefutable that says two young black kids out drinking in the middle of the night in San Bernardino, one of them dies, it's worth $110.8 million. So set your fucking reserves accordingly, right? Pay out reasonable demands accordingly. These verdicts help establish settlement value for all of us moving forward. So next time somebody is looking at a case in San Bernardino on paper thinking, well, that might not have the value that y'all assume because it wasn't a rich guy making $1 million a year with a cute family, like maybe it's still worth $110.8 million. And in fact, not maybe, it is. It is. And if you can tell that story to the right jury, you're going to get it. So behave accordingly. Now, here's another benefit. I know I can do a 9-figure verdict now. I had done, 7-figure verdicts. I thought that was great. Felt awesome. You know what I mean? Yep. And then I got an 8-figure verdict. And that felt awesome. And if I'm being honest, I was like about the top of a career that I would ever expect. I thought 9 figures was kind of, I don't know, so far beyond reach or silly or something. But I can stand in front of 12 people and talk about over $100 million and have them agree with me. That's important for me and my development and the clients I'm going to represent next. You have to have belief in yourself that you can do it before you do it. But I'm going to tell you, after you do it, that level of confidence that you have within yourself changes. It changes. So now I'm more powerful on behalf of all my other clients, because if I've got to go all the way and extract absolute full value from a verdict, I prove to myself that I can do it.
It's unbelievable. It's just, I want to thank you for being so raw and authentic in the email that you sent, across the listserv and in coming here and in talking about things that we don't always talk about. We love talking about the cases where we're collecting money. We love talking about cases that went perfectly and that we won. And we don't talk enough about these kinds of cases where you still learn something along the way, where you still are fighting for the real reason why we're doing this in the first place. So thank you so much for coming onto this show and for speaking with us. It's a privilege to hear it from another attorney.
I'm so flattered that you paid attention to the email and that you gave me a ring to do this, because one other thing I said in the email is the first question everybody asked me after they heard about the verdict is, are you getting paid? And I'm guilty of that too. So here's what I want to say. Let's be careful about that question. Let's be careful about that question, because I think it fuels the superficiality of what we do. And I think that we need to fight against the superficiality of what we do, because it's not just clocking big numbers and giving each other awards. At the end of the day, we have the power to meaningfully change people's lives, and that's not always with money. So you can ask if it's getting paid, but I think there's other questions that we should be asking people about their successes as well. And, I feel this thing where it's like the minute people realize it wasn't going to be paid or wouldn't be paid immediately, for a lot of people, it took some of the luster off. And that affected me too. I guess it's not real. I'm not supposed to talk about it, right? So I kind of didn't. I kind of just hopped into more trials and moved along. And then it just sat with me too long. And I was like, I just think we have to talk about what we make other than money. And I'm really thrilled that you gave me an opportunity to do that.
100%. It's absolutely my pleasure. Folks, most trials come and go, files close, checks get written, people move on. But some trials and verdicts are not just entries in a docket. They're declarations that say these young men existed. They mattered. We saw them. We will not let the final word be the lie told about them on the pavement. What Brian and his team did was not just win damages, they changed the narrative for a grieving mother, for a community that's been told too many times that their children are disposable. and for a system that needed to be forced to look itself in the mirror. And maybe the check never comes, maybe it will later, maybe the state hides behind technicalities, maybe the accounting ledger doesn't balance, but a jury, American citizens in a county most people overlook, looked at the life of these young black men from San Bernardino and said they were worth 9 figures. And nobody can ever take that back. That's the power of trial work when done for the right reasons. When we step into the arena, not just to win, but to bear witness. Because sometimes the job isn't just to get money. Sometimes the job is to make sure the truth gets recorded in the one place where society is forced to listen, a courtroom. That's the importance of jury service. Brian, thank you so much for trying this case. Thank you for standing up when the law tied your hands. Thank you for continuing to keep going for this family and for all of the clients that you represent. It's the voice of the community speaking back here. This is Trial Bible, where we don't just talk about how trials are won, we talk about why they matter. See you next time. That's a wrap for this episode of The Trial Bible. We hope you've gained some valuable insights. Don't forget to subscribe, rate, and review so you never miss an episode packed with winning tactics and expert advice. Thanks for tuning in.